All right, well, we are happy to start our third panel of the day focused on remedies. Our moderator today is Celine Krausen, who is a partner at Hogan Lovells. She's a first-chair trial lawyer in patent cases in both district courts and before the ITC. And she has also been at the forefront of USPTO patent challenges, leading a practice there. She's been involved in numerous inter-parties review proceedings and is also handling the first ever instituted post-grant review proceeding at the USPTO. We're thrilled that Celine can join us. She is an adjunct professor here at Georgetown, so you're familiar and part of the family. And we're thrilled that she could moderate the panel today. Thank you.
Thank you. Hello, everyone. Thank you for joining us, especially on a Friday afternoon. As Alex mentioned, I'm Celine Krausen, a partner at Hogan Lovells here in Washington, D.C. I'd like to introduce my panel to you. Immediately to my left is Morgan Chu. Morgan is a partner at Irell and Manella. He's the chair of the litigation group, and he's been touted by Chambers over many years as the most gifted and talented trial lawyer in America and has won a Chambers Award for Excellence. Sitting next to Morgan is Matt Powers. Matt's a founding partner at Tensegrity Law Group in Silicon Valley. He specializes in patent litigation and trials and handling some of the most complex cases for technology companies. Then we have Professor Bernard Chow. Professor Chow is a professor at the Denver University Law School. He's the director of the law school's intellectual property program and a co-director of the Empirical Justice Institute. And before joining the University of Denver, he was a practicing lawyer in Silicon Valley, where he specialized in representing technology companies in high-tech patent litigation. And then we have Ken Correa. Ken is the senior VP and head of the US IP in Silicon Valley for Samsung Electronics. He's been practicing for almost 25 years in IP litigation and technology licensing. And before arriving at Samsung, Ken clerked in the Northern District of Florida and was a federal prosecutor as well. So thank you all for joining us today. As the panel title indicates, we're going to touch on some remedies, hot topics in patent infringement cases, including damages, standard essential patents. Perhaps we'll get to enhanced damages and injunctions, and we're going to treat our panel in a very interactive fashion. We'll take questions at the end, and we may interrupt each other if we have thoughts or ideas. We'll also try to present some topics that aren't often discussed, when it comes to patent damages, such as how to influence juries, the use of surveys, and some other research that Professor Chow and others have been looking at. So first, turning to Morgan. Can you set the table for us a little bit and give us some background on how courts look at patent damages and tee up some of the issues regarding, for example, apportionment and other things that go into calculating reasonable royalties and lost profits in patent damages?
Hello, everybody. First of all, thank you to Georgetown and Berkeley for inviting me and the other panelists. Among intellectual property conferences, this is among the best of the best, so it's a terrific conference. Patent damages are interesting because I think in the last decade, it's been the area that's been changing most rapidly in all of patent law. All those changes are court decisions. And if you go back just 10 years ago, it was exactly 10 years ago that the Lucent versus Microsoft trial court decision was rendered. And it was 2 years after that, meaning 8 years ago, that the Lucent Federal Circuit decision was rendered. And then we had this accelerated pace of Unilock, RescueNet, Laser Dynamics, and it goes on and on and on and on. Now, putting both apportionment and the entire market value rule into context, I think it's easier to think about patent damages as a whole first. Patent damages as a whole looks to the value of the patented feature in the infringing product. That is an unremarkable proposition. And all of the side discussions about when the EMV, entire market value rule, applies and what's proper apportionment and whether there should or shouldn't be a 25% rule of thumb or the Nash bargaining system for which Professor Nash won a Nobel Prize can be used in courts, and all the other side debates are within that context. The unremarkable proposition that damages should be based on the value of the patented feature. So let's look at apportionment in particular. Let's say there's a pharmaceutical drug and there's one patent that covers it and it covers the active ingredient. In that case, the demand for the product is driven by the patented feature. It's not driven by doctors or patients who say, oh, that's a drug from Pfizer or Merck or GlaxoSmithKline and the dozens of other great pharmaceutical companies. It's not even driven by the color of the pill, even when a pharmaceutical company tries to promote a particular product based on the color of the pill. It's based on the active ingredient because it successfully treats a particular ailment. And therefore, damages can be based under the EMV law as it exists today on a percentage of the total revenues, whether it's 1%, 10%, 30%, or something else. In contrast, many products have many different features, and the patent may only cover one of those features. And that's quite common in the electronics industry. That's common with smartphones, that's common with laptops, and many other electronic products. And it's there that apportionment has become king. It is very important, so important, I would say, in the last 8 years, the beat of the patent laws decided by the Federal Circuit has been apportionment, apportionment, and apportionment. And so what that means is that if you have a smartphone and the patent just covers the brightness of the screen, the patent owner can't capture damages based on the fact that the manufacturer of the smartphone has a big app store, that it has a fast processor, that it has facial recognition, to use a random example, or anything else. It's got to be based on, at a beginning point, on that bright screen. So that's where we are today. Both the EMV rule and all is what's discussed in the case law and apportionment is in that unremarkable context that patent damages must be based on the value of the patented feature.
And, we've talked before about patent damages including, or most of us know that patent damages include both lost profits potentially and reasonable royalty as a floor. Is it fair to say that apportionment typically comes up in the context of reasonable royalty rather than lost profits?
Well, there's a big maybe because of a particular case, and rather than my delving into that recent decision this year, apportionment certainly does come up in connection with reasonable royalty. Most of the cases involve that, and I would say that the Mentor Graphics case, which was recently not decided by the Federal Circuit, in the sense that there was a panel decision, there was a district court decision, a panel decision, and then a petition for rehearing en banc. And, well, maybe just to give people a little taste, I think there were 12 judges of the Federal Circuit deciding whether to take the case en banc. The court as a whole affirmed in a per curiam decision. 6 judges wrote one opinion. 2 judges wrote another opinion. The 2 judges who wrote what might be considered a dissenting opinion said that the other 6, who were not writing for the court as a whole, had done away with apportionment for lost profits. And the 6, again, that's not a majority opinion, we're basically saying, oh no, this is a narrow decision, but I think it'll probably spark a more detailed discussion among other panelists.
Yeah. And Bernard, if we could turn to you, while we were speaking with each other before the panel, I saw one of the articles that you've written as to whether or not apportionment, and if so, how, should apply or could apply in the context of lost profits. And I'm curious as to your thoughts on that.
Yeah, I mean, so this is delving into the Mentor Graphics case, and essentially the question is, does apportionment apply to lost profits? The answer is yes by actually all the judges. It's just a question of whether or not, how you do it. And for the 6, I think the answer is apportionment applies, but if the component actually is such that we have causation and it causes customers to actually buy the infringer's products instead of the patentee's products, well then that somehow has incorporated apportionment principles because it must be that important a feature. And therefore we don't have to do anything further, and all the profits are then attributable to the patented feature, and the patentee can obtain all the lost profits. And I would say the 2 judges that were mentioned sort of disagree with that point of view, and I'm sort of have written an article that's sort of going to be published in 2018, arguing that in fact apportionment that's a fiction. You know, that recognizing that apportionment applies to lost profit means that you can't give all the lost profits for a single feature. That even if it is a driver of customer demand, there may be hundreds of thousands or whatever number of features in these complex multi-product products, that therefore we have to sort of divide it up, and so that lost profits by itself does not account for apportionment. And I think that's the rough disagreement between the 2 sides.
So I'd like to respectfully disagree with my friend Bernard.
About the characterization?
No, I think the characterization is, so the actual decision, obviously it's very fractured on the en banc denial, but the actual decision was that no further apportionment is required in a lost profit analysis once the Panduit test has been met. And there's debates about whether meeting the Panduit test in a particular way is required or not, and we'll leave that to the side for a minute. But as a matter of analytics, in theory, if you've met the Panduit test, you have proven by one means or another that you have lost X number of sales. And if you lost that sale because of the infringing activity, you can't parse the profits you've lost from that sale. You lost the sale, you lost all the profits in that sale. And so I think that's where lost profits vary substantially from reasonable royalty, because as the court recognized, the Panduit test is a stringent test. If you meet that, you are deemed to have lost the sale. If you lost the sale, you lost it all. And I think that logic is impeccable, and we'll see how it develops. It certainly is a disputed question. The issue isn't, I think, whether apportionment is required. The issue, as posed by the panel decision, is whether apportionment is inherent in finding the Panduit analysis test satisfied. And that's where we'll be going from there, but that's at least my personal view.
Excellent. Matt, sticking with you, can you talk a little bit about some of the more recent issues that courts have addressed when it comes to how comparable licenses fit into patent damages analysis, and set some context there?
Well, the basic concept of the comparable license analysis is similar to how Morgan described the apportionment analysis, straightforward and unremarkable. The licenses you're using have to be sufficiently relevant to be something that is appropriate to give to the jury. You can't give, and there's technological comparability and there's economic comparability. The 3 issues I have with that body of law is not so much in the basic conceptual framework of it, but how it's applied. And the first issue is, in my mind, a question of when district courts intrude into the province of the jury in this area, in areas where they wouldn't otherwise. it's essentially a 403 analysis, I think. Is it so irrelevant that the jury shouldn't see it? Or is it something where the jury can weigh its significance and relevance based on the experts and the parties' arguments about the various things that make it different? It's obviously the case that you're not going to have any license that's perfectly comparable. You're going to have different parties, sometimes even different patents. You're going to have different time frames. You're going to have different levels of sales. You're going to have lots of differences. So you can't require perfect comparability. And then the question is, what ought the judicial standard be to limit the evidence from actually going to the jury versus putting a thumb on the scale on the merits? And I think the first problem that I have with this body of law is that I think a lot of district courts, in the context of Daubert motions, are putting a thumb on the scale on the merits rather than properly performing a Daubert role, and thereby they're intruding into the jury's role. And the jury is more than capable of using a BS detector if you're having a very unreliable license agreement that has no bearing on it. They're going to see that and punish you for it. And I think that a lot of what's happening is just judges are not trusting juries enough, and my view is they can be trusted to do that. The second problem I have with the way this analysis is being done in the courts is there's too great a divergence from the real world. In the real world, it is often the case that you'll have, so one example, for example, that comes up is whether a portfolio license, which includes the patents in suit, is sufficiently comparable to be admitted on the value of some of the patents in suit, even though it's not for the entire portfolio. Comes up in almost every single case. And there are intense debates about that question, and often courts keep it out on that ground, because how could a license, they ask, of 5,000 patents be in any way sufficiently comparable to a license that are for 5 patents or 10 or 2? And the answer again comes down to the real world. In those license agreements for 5,000 patents, the parties don't sit down and value all 5,000 patents. In fact, there's going to be 2, 5, or 10 patents that drive the discussions between those parties. And I've been in those discussions and I've watched this happen, and that's how the world works. And if those patents in suit were in fact part of the drivers of the discussion that led to the portfolio license, to say that that portfolio license is not representative or at least sufficiently relevant to the value of the patents in suit, it just ignores reality. Now, obviously, there's a difference because they got something more. And the experts can debate what that is and talk about it. But to say that it's not even admissible when it's the same patents and a competitor of the defendant, merely because it's a portfolio license, ignores real life. And that is real life. And that's merely one example of many where the discussions about relevance are divorced from how the real world works. The third problem, and last, that I'll talk about, at least in this context, is an absolutely fruitless, never-ending search for precision or accuracy. The law of damages has inherent uncertainties, inherent unknowns, inherent questions of degree. And if plaintiffs are required to eliminate those or come close to eliminating those, no one will ever get damages. And I think it's when we're going down the path to conjoint surveys, which we can talk about later, and other things, all of that is an attempt at a level of certainty which is not possible in this field. So we have to, I think, readjust our expectations about what's possible, what plaintiffs actually have to prove, and who ought to bear the burden of that uncertainty.
Can I add to what Matt was saying? When you think about comparable licenses, naturally, I think, one would say, isn't that the best evidence? So one oddity that developed was that there are a bunch of district courts who say, if it's a license agreement without litigation, it comes in, and if it's a license agreement that came about after a lawsuit was filed, it stays out. But in every patent license negotiation that I've ever known anything about, whether it's from the patent owner side or the person who wants the license, they all know what happens if the license negotiation fails. You end up in litigation. And indeed, the filing of the case is just part of the negotiation often. Second oddity is this. The courts develop legal theories and legal tests that seem to make a lot of sense. So now I'm going back to the entire market value rule, which says, say, for electronic products, you can't apply a percentage against the total value of the product. But almost every license that involves a running royalty, as opposed to a lump sum royalty, is based on a percentage of the total revenues. No one ever sits down and says, well, I'd like a license for my smart tablet, for that brighter screen, and tell me, let's see how we do the apportionment analysis. The word apportionment never comes into being. The discussion is you're going to get 0.03% or 1% of all my future sales for a certain period of time. So the entire market value rule as it's developed in the courts, standing alone, seems to make a lot of sense, but it is totally at odds with the real world license negotiations. And think about the fact that Georgia Pacific has stood for almost forever in terms of patent damages in the modern era. And it talks about the hypothetical negotiation as if it was a real negotiation, but then we have this extension of the EMV law, which totally clashes from what happens in the real world.
I totally agree with that. I think it's an excellent point. But one additional point on the relevance of settlement agreements. You'll see courts citing some old law saying settlement agreements really aren't effective values and are artificial because of litigation. Well, first, they're not artificial because litigation is always there. But second, we're putting aside the case where you're talking about a very nominal settlement agreement, which is below the cost of defense, and that I get the argument for. If you have a very substantial settlement by a very substantial company, the idea that that is inflated because of the presence of litigation is nuts. Because, in fact, the negotiation of that settlement takes into account the very things that are assumed not to exist in a hypothetical negotiation, which is intense debates about the validity of the patents, debates about whether they're going to survive IPR, intense debates about non-infringement defenses. Those are the things that depress the value of that settlement agreement. So, in fact, when you're talking about the use of a settlement agreement against a comparable competitor, against competitor number B, that the value of that should be higher because, of course, in the hypothetical negotiation, you assume validity, you assume infringement. And the courts have that just backwards. And the idea that you can't use that at all, which some courts have done many times, it just reflects a real misunderstanding of the real world and the law that started all this thing about settlement agreements.
Ken, we've been listening to the different views of Matt and Morgan when it comes to handling damages issues in front of courts and juries, but from the in-house perspective, Samsung Electronics is obviously involved in a lot of patent litigation. What are some of your thoughts about how some of the damages approaches are being applied either in theory or in some of the real-world contexts that Matt and Morgan were just talking about?
Okay, so first, a disclaimer. Whatever I say here is my own opinion, not that of my company. I talked to other in-house counsel in the tech industry about damages issue, and one of the problems or one of the issues we see with the current damages landscape is that it doesn't really reflect realities, even after application of apportionment. In the tech industry, especially in the information technology area, the norm, the reality is that any technology, any new technology will go down in value over time, sometimes dramatically. Think about flat screen TV. You could probably bought 60-inch TV like 5 years ago for like $5,000. You can probably pick exact same one today for maybe $1,000 or less. The price goes down. Depreciation is the rule rather than appreciation. Yet that reality seems to be turned upside down when it comes to patent damages. There's a case known as laser dynamics. We made it available as part of this program. If you looked at it, back in 1998, patent owner licensed his patent for $56,000 lump sum. 8 years later, when he went to litigate that patent against BenQ, he ended up settling that case for $6 million, about 100 times more than his original amount. 4 years later, when he went to first trial against Quanta, the jury verdict was $52 million, almost 1,000 times more than the original amount. That doesn't happen in the industry. A technology doesn't get 1,000 times more valuable after 10 years after it has come to use. So why is that? I think the problem is the overemphasis on comparables when you really don't have good comparable licenses. We talked about how some of these licenses are not really comparable, and it's what strikes me odd with what's going on today is that we don't seem to use other evaluation methodologies other than comparables. If you don't have good comparables in other industries, they'll use other methods, such as you look at the cost of building it, you look at the cost of replacement. I think some of those things are actually coming to play. I think people are beginning to talk about cost of designing around, cost of building features. But I think we really need to take a look at what's going on and whether there's any better way to measure damages than simply comparables, because oftentimes comparables do not reflect realities.
So one quick point, following up on Ken's point, I do think there are situations where the value of a patent can increase dramatically over time. Often, and it's quite often the case that a party will come up with a patent and there's been no use of that patent yet at all. Its value, extent of adoption, et cetera, will be quite speculative at that time. The value of the patent might then be viewed as being quite small, but 5 to 10 years later, if that patent has very, very widespread adoption, is used in every flat screen TV, even if the price of the TV has come down from $6,000 to $1,000, if there's now 100 million of them instead of 1,000 of them, the value of that patent can now be much greater than it was 10 years before. And that often happens in this industry.
So building upon both Ken and Matt's point, intellectual property is really interesting. If you think about it, think of personal property, like a car. It doesn't matter whether you own it or I own it. Its value is the same. It's the same car. It's 1 year and 10 days old. Nothing's happened. I buy it. It's got the same value. Real property, it's basically the same. You might say a commercial piece of raw real estate is worth more in the hands of a commercial developer, but if someone's just a wealthy investor, he's going to sell it to a commercial developer. So the piece of real property is going to be roughly the same value because the developer is going to take risk and make investments. The value of a patent can easily change tenfold in one day. And I'll give you an easy example. Someone owns a patent, doesn't use it, and sells it to Ken. And Ken is in business and makes a product and asserts the patent against a competitor, and assume only 2 competitors, Ken has a lost profits claim. The first owner doesn't have a lost profits claim. The lost profits claim is frequently many times greater than a claim just based on a reasonable royalty. Same patent, transfer to a new owner. By that virtue alone, that piece of property, unlike personal property or real property, can have a multiplying effect on its value instantly.
Yeah, well, to add that, if you sell it to a practicing entity, you can get it more likely to get an injunction, so it's legally more valuable in some sense. But I did want to point out something with respect to what Ken said. I think this is a good opportunity to talk a little bit about what I was going to discuss with Ken's very high verdict that he was concerned about, and that I think one sort of frequently ignored area is sort of just thinking about decision-making. So everything we've been talking about is sort of making an assumption that the decision-makers here are perfectly rational and are applying these rules in a very rational and rigorous manner. And one of the things that I've been thinking about is I think that we actually present patent trials, and particularly the remedies section, in a way that actually sort of exposes some sort of heuristics within the jury. And what I mean by that is I think that oftentimes if you ask for like $60 million or whatever it is for a single component, you actually sort of are, the plaintiff is putting up a big anchor there, which actually creates the frame from which they decide. And there are numerous or countless studies sort of in the psychological literature that show that if you put up a big number, you're more likely to get that number, you know. And then second, I think that because the patented feature is so prominent in the litigation itself, maybe there are 1,000 features in the particular phone or computer device that we're talking about, then the jury sort of overinflates the value of that feature vis-a-vis all the other features that are involved there. And I think that can be just as powerful an explanation for the verdicts that Ken is concerned about. And I would, you know, it's an empirical question, but I would say it's probably more likely the explanation than the explanation that Matt is giving. It's a very possible one, that the value of the feature has increased over some period of time and has become so powerful. But so one thing that, you know, I think that that as damages develops and we keep on thinking about is to think about both ways to reduce the sort of cognitive bias that juries have and judges have, both in the terms of judicial instructions and how they make their determination and how we allow litigants to present those arguments.
Yeah, so let me respond to some of the comments. I think the one thing you really need to look at it is that yes, there's a litigation aspects to patents, but I think what we really want to get to is that reasonable royalty. I'm really talking about multi-component products, where each feature may be covered with many, hundreds of different patents. And oftentimes you deal with the companies, they try to sell that technology, and then later they decide to assert that patent against you. And when you look at from business reality, really doesn't that company probably spent a certain amount of money to develop that technology covered by their patents. But oftentimes where they have not succeeded is that they could not come up with investment. They could not take the risk that was necessary to make that technology a commercial success, because it doesn't cost that much money to build that technology. Where most resources go into is actually commercializing the technology, building the sales and distribution network, and successfully selling that technology. That's where the real risk is. And oftentimes defendants are at a loss because we took that risk. We made that technology success. It's not the effort that got into making the technology, but more risk was associated with incorporating that feature into your products. And so why is that all of a sudden the patent owner gets to claim the benefit of the risk I took? So I think that's where realities do not coincide with the patent damages award.
Well, something else that is coming into the valuation approach are surveys. It used to be that in intellectual property, we only saw surveys in the context of trademark cases, and every trademark case involved a survey. But now we're seeing them consistently in patent cases, and I think it pays to spend some time on that. Bernard, I know you've done some research in that area, and you have a couple of slides. I'm not sure if you want to
Sure.
up the use of surveys or rely on one of your panelists to do that, but
Can we go to the next slide after this?
Sure.
I think just the table. Yeah, so this is actually both a source of interest and frustration of mine. And Matt, I actually have asked Matt to help out on this a little bit. So there's been a new technique in multi-component cases to use something called conjoint analysis to figure out what the value of a particular feature is. And this is the province of high-priced economists. And I was able to, I've been trying to study this, and essentially, and Matt, correct me if I'm wrong, more or less the idea is that we present a survey to different individuals, and we give them a lot of different features, not all the features, because it's impossible to ask a question with all the features, so maybe a subset of 7 in this particular case. This is taken from Pacer from the Apple Samsung case. And simply the question is, you ask, well, do you want this phone or this phone? Do you want this phone or this phone? Do you want this phone? And they keep on varying the features, right? And varying the price and all that kind of stuff.
It's like an eye exam.
Yeah. And so, and through so through a combination of, I think, I assume fairly fancy math, you come out with the value of the particular feature. Now, this is my opportunity. I don't get an opportunity to complain as often as I would like to a large public forum. Maybe there's some judges. But so I tried to study this. I was planning to write some amazing paper that would appear in an incredible publication. And so I tried to get every conjoint survey analysis that I could in every multi-component case. And actually, every single one of them, most of the evidence was sealed. This is the most I could get out of it. And so I couldn't even figure out what the methodology was or whether there are weaknesses. There's inevitably a Dalbert motion that says exclude it, and there may be an order granting it. And sometimes you would get part of the Dalbert motion, most of the time you would not, and then you would get an order saying, wow, that really made a lot of sense, granted or denied. And so it was impossible for me as an academic to actually tell you anything more than what I've just told you. So I don't know if Matt can help out.
Well, I'll help in one respect. The guy's name was Dalbert. He wasn't. He was not French.
How do you know it wasn't a woman?
Because he was a plaintiff in a case in Southern California, and his name was Dalbert. So this is an example of what I was calling the search for false precision earlier. In the old days, when you did a survey, you did sort of a trademark style survey, and that survey was not designed well for a patent context, particularly in the context of apportionment. And the FJC and others came out with a set of guidelines essentially for how you should try to do typical trademark style surveys in the context of patent cases. And if you followed that, you probably ought to be cleared under a Dalbert motion, but they were highly imperfect. There are a lot of ways to skew those sorts of surveys, and a lot of people were skilled in the art of skewing them. Conjoint analysis is a different beast. It has a highly developed academic literature. It is, as a methodological tool, as sound as anything Dalbert should ever bless. Now, its application, obviously, the devils are in the details, as they always are. There are ways you can violate the typical ways you would do a conjoint survey. But whether it's a methodologically sound system, which is what Dalbert's about, as opposed to whether it was done properly in this particular case or done in a way it was designed to skew it, which is, to my mind, really fodder for cross-examination in front of the jury, that line is getting blurred like crazy in Dalbert motions across the country. And that's a really good example of, I think, judges intruding into the province of the jury under the context of a Dalbert motion. But the basic principle of a conjoint survey, and again, there's a very robust academic literature about this, is that it is able to isolate to some degree, not to a perfect degree, the influence of particular variables in a multivariable analysis. And it's not just products, obviously, it's a lot of different things. But that's the basic theory behind it. And it will always be imperfect. The Nash bargaining solution is another really good example where I think the Dalbert motions are intruding again into the province of the jury. And the contrast between that and the 25% rule is perfect, I think. The 25% rule was something based on a couple of companies in Switzerland in the 1950s. And it had really no methodological approval in any academic literature. You contrast that with the Nobel frickin' Prize. That's a little different type of animal. And yes, Nash, there's a robust academic literature there that says, here are situations where Nash might be appropriate and here's where it might be inappropriate. And I think it's appropriate under Dalbert if the expert proffering the Nash bargaining solution does not attempt to justify it under the academic literature when Nash is appropriate and not, okay, now that you can keep out. But if that expert does so, then it's a subject of cross. Now, you've now way past the line of where Dalbert ought to be used to keep something away from the jury. And there's several other examples like that where, again, the basic methodology is strongly supported in peer-reviewed academic literature out the wazoo. Now the question is, obviously no single methodology is going to be appropriate for every single case. And most of those techniques have a fairly well-developed body of criteria saying here's when it's more appropriate and here's where it's less. And the question is were those followed or analyzed or not. I think that's the right way we ought to be looking at it.
Let me add to this because I think the phrase conjoint analysis is something that should put most of us to sleep. But its basic principles are really pretty easy. The attempt is to determine how much consumers, or whoever the buyers are, will value a given feature when a product has a sea of other features. So that's the goal. So major companies do this all the time. They do it all the time because they want to be able to price their products sensibly. So I'll give you an example. Apple and Samsung. You buy a particular phone with memory size small, medium, or large. Each step up, it depends on the phone, it depends on the time, but typically you pay an extra $100. And there's empirical data. This is how many people bought the small memory, how many people bought the medium size, and how many people bought the large. And in fact, conjoint analysis doesn't have to be based on a survey of consumers taken at a time during litigation. It can be based on real-world evidence of what consumers actually did. Think about an automobile. How many people got the larger size engine? And you could go through almost every other feature. How many people got a GPS system put into their Honda Accord? So in fact, there is a lot of real-world evidence that's unrelated to litigation. Sometimes there's survey evidence that predates litigation, and then there's survey evidence taken during litigation. And then there's another phrase that at least some of the people here may be more familiar with, which is a regression analysis, a multiple regression analysis. This is decades old, is being used, and all it seeks to do is to take a bunch of independent variables and see if there is a correlation and maybe some cause and effect between them and a dependent variable. And that's been done in so many different areas, in economics, in just about every field of social science, in public health, and in every other area. So I agree in spades with what Matt said. These tools are well-known, tried, proven tools, but the real devil in the traditional battling surveys, whether it's in a patent case, which has been around a long period of time, or in a trademark case, which is the traditional area, is how those surveys are designed. And every single survey is subject to criticism. And then at a certain point, if the points of criticism mount up to be big enough, material enough, then a court should be throwing out that survey evidence. But it's a very much a gray area.
So 2 points. I agree with both Matt and Morgan that conjoint analysis is a valuable marketing tool, but I think it becomes a problem when you apply that conjoint analysis to patent damages. First of all, conjoint analysis really is trying to test consumer preference for certain features, and when you're trying to apply it to multi-component products such as smartphones that have thousands of features, how do you design a test that will actually isolate one feature out of 1,000? And it just, I just don't think that that's really practical. And second point is that oftentimes, you are trying to use conjoint survey to say that consumers prefer emails to the tune of maybe $10. They're willing to pay $10 for email features, when in reality, the patent claim really goes down to much smaller, much more detailed level of preference. Maybe that patent feature covers email push notification, or not even that. Typically, it's a maybe a single feature out of that email push notifications, or one of the ways you deliver that email push notifications in a certain way out of many. So when you get when you say consumer is willing to pay $10 for these email features, there's really no good connection between that and patented feature at issue. So I think that's where I see problem of using conjoint analysis.
Although that particular thing, issue, right, is again an issue of design, and theoretically, the way we would design that, I assume, and I haven't done these, is that you would put the email with and without the feature, but not delete email, right? And if they took out the email, you'd say that's a methodological problem. And my whole big beef with this is that right now, as I perceive it, and maybe the judges that remain might lend more insight, which is the judges are probably at this point relying purely on expert witnesses from both the plaintiff and defendant, because those of us that also want to inform the judges can't tell you what are the best and worst practices of this, what I call sort of secret damages field. And so it is it's insulated then to just the advocates at this point.
So I think Ken's point in the context of smartphones is a fair one. It tests, I would say, the limits of conjoint analysis when you have thousands of features, but everybody always says thousands of features. There probably aren't thousands that really matter to a customer,
I could say billions and billions.
you'd be wrong, but okay. There's not billions. But the larger point I wanted to make is, yes, of course, you're going to have imprecision and some inaccuracy and inability to narrow it down to a particular feature out of thousands, of course. But who bears the risk of that uncertainty? Is it the plaintiff who's got a valid patent that's been infringed? I mean, that's the presumption of a damages analysis, right? Or is it the infringer? And this is another example where real life again intrudes a bit. Despite all of those uncertainties, despite the imperfections of the ability to test one or two features out of thousands, in the real world, companies actually use this tool to do exactly that. And they base decisions on it. They base decisions on what features to include, on how to price them, and other things like that. Yes, they're imperfect, but that doesn't mean they shouldn't be admissible to a jury and have people argue about it. And that, to me, is the larger point. What is the level of gatekeeping that's applied to that? And when the real world people use these tools for this purpose, why shouldn't juries be allowed to see it as well?
Do you see a trend as to where the use of surveys is going? I mean, will it continue to focus on a battle of the experts and an analysis that was done between folks on the street, or will there be a looking to what companies are actually doing internally?
So that's a bit of a beef of mine. This is what I was referring to earlier as search for false precision. The whole Daubert excesses have pushed people to do these very expensive surveys, which have false precision but not actual precision. One of my beliefs is that often the best evidence of the value of the patented feature is not quantitative data done by a conjoint survey, but the qualitative information in each company's files about why they included that feature in the first place. And yes, that's not going to provide precision in terms of a quantitative number that you can use, but it's a pretty good indicator of what that company thought the value of that feature was. And yet that evidence is often ignored and poo-pooed as not being sufficiently quantitative. And I think that's a flaw in the current way of thinking about this issue.
Excellent. Well, we know that damages can be determined by juries, and really the only thing that's guiding them is all of these approaches and case law that we've been talking about. All of us on the panel have tried patent cases, and we've done some thinking about what works with juries, what doesn't work with juries. And Morgan, maybe you can start. Do you have some thoughts or tips about, from your experience, what works with juries when it comes to remedies in patent cases, and what doesn't work?
I have a lot of thoughts. I'm always learning, which means my thoughts from yesterday, I learned, were not very good thoughts on particular issues. And I'll give out a few tips, but not all my tips. I'll use a real case. So about 3.5 months ago, the district court entered a judgment after a jury trial. In the interest of full disclosure, we were representing the interests of the University of Wisconsin. The actual named plaintiff is WARF, W-A-R-F. They managed patents from inventions from the University of Wisconsin, Madison. WARF stands for the Wisconsin Alumni Research Foundation. And the defendant was Apple. So the judgment that was entered by the district court after all the JMOL, post-trial motions, were decided was $506 million. And thinking about the practical issue of damages today, against the background I first mentioned, where in this 8-short-year period, damages law for patents has been changing at a lightning speed. The way we thought about it, the way I think about it today, is in the context of thinking about the great Wayne Gretzky. Now, I don't know why we say great, because we never say the great Babe Ruth or the great Muhammad Ali. But the great Wayne Gretzky, one of his part of greatness was the quote that he doesn't skate to where the puck is. He always skates to where it's going to be. And so that's what trial lawyers do. You're preparing for a trial in year 1, and it's probably going to get to the federal circuit in year 3 or perhaps later than that. And if the area of the law is changing a lot, you want, if you're successful, to be in sync with the law 2 or 3 years later. So, as a practical matter, we had 7 expert witnesses. This is just one side. 7 expert witnesses who testified on some aspect of damages. And there was a host of fact witnesses on both sides as well. So obviously you need one witness who brings together all the numbers and adds them all up. So that's one witness. The case was on a single patent. I was listening to the earlier panel discussion this morning about these cases that have an infinite number of claims and 10% of infinity of the number of patents. We brought the case on a single patent, and it had to do with increasing the performance of a processor. So let me put it in the context of apportionment law. We didn't say we want a percentage of the sales of iPhones. I mean, we told the jury expressly we don't want that. There's a piece of silicon in each of the iPhones. It's called the system on a chip. It's one piece of silicon. And we said, we don't want damages based on the system on a chip. By the way, the smallest saleable unit, which crops up in a lot of case law, smallest saleable unit is the entire iPhone, because the chip is designed and made by Apple, and they don't sell it independently. So we said the SoC, we don't want damages based on that, because it has graphics processing capability and other things. Part of the SoC is the CPU. The traditional CPU. We said we don't want damages based on the CPU. We want damages based on this very small number of transistors that increase the performance of the processor. And Intel said the entire piece of silicon has billions, literally billions of transistors, and your invention, alleged invention, is incorporated in a small handful of transistors, and that ought to be a major variable in terms of the amount of damages. And we said, ha! The beauty of this invention is it takes up very little real estate. It doesn't cost 1 penny more to make those additional transistors in that sea of billions of transistors, and it improves the performance by 8.55%. And we had 2 experts on performance improvement who ran different benchmark tests. We had another expert who was a chief architect of a processor company in the past. We had an expert on the increased battery life, which is caused by increased performance. And oh yes, we had an expert from MIT who performed a conjoint analysis. And let me use that as a good segue to the survey part of this discussion. In a sense, there were 2 kinds of survey, one based on real-world information that existed long before the litigation. And the iPhones, of course, do have thousands of features. But there is always a market for the last model and 2 models earlier, still in the United States. You can buy an iPhone 7 or an iPhone 6 today in the United States. You can buy new models of it. But in addition, there was a point in time where Apple introduced, I may have forgotten the exact model numbers, but I think they called it the 5C at the time they introduced the 5S. Remember the C had different colors? And there were only a handful of differences. One was the 5C had the older processor. That was a big difference. The other is the 5C had colors, which was a consumer preference, so it's going in the other direction, and the 5C had a plastic case instead of a steel case. So we said, well, that's pretty easy to isolate those differences, and then in addition, there was a consumer survey, and then the conjoint analysis was applied, and there was some other expert testimony on top of that, which included licenses and comparable licenses. And in fact, one of the licenses here was exactly comparable because WARF had granted a single patent license to a processor company for a certain sum of money. It was not a portfolio license. It was only a license to the patent in suit to a competitive processor company. So 7 witnesses to build a damages claim. Now, as a practical matter, that raises a policy question. If damages law has gotten so complex, how does the damages claim that might result in a $30 million damages verdict get to trial in an economical fashion?
Matt, do you have any comments on what works when it comes to damages in front of juries and what doesn't work?
Well, I would say, to shorten it, since we're running out of time, I would say pigs get fat, but hogs get slaughtered. The mistake I see on both sides of the V is a plaintiff will present a damages number that's pie in the sky, not tethered at all to any facts based on the case, and the defendant will do something that's about $10,000 or $15,000, and you have one that says it's worth $500 million and one that says it's $15,000, and I think doing that loses credibility on both sides and is a mistake. Sure, you want $500 million, and sure you want it to be $15,000, but it's not going to be either, and you might as well stake out credible ground supported by the facts of the case and think it through. The other point I'd make is damages have, for a very long time, been sort of the redheaded stepchild kept under the stairs in a patent case. The damages analysis wasn't done till the very end of the case. It was done almost as an afterthought. It was presented in an hour and a half or so at the end of trial. And that was partly reflective of the state of the law at that time. The state of the law at that time was, here's Georgia-Pacific factors. Here's an expert who's going to say, oh, this one goes up, this one goes down, this one goes sideways, $500 million. And those days are gone, and they should be gone because they were analytically undefensible. But I think it's still the case that too many people don't build the damages case from the beginning and integrate it into the rest of the case in your thinking. And that results in damages cases that aren't particularly well thought out at the end, that often aren't linked to the technical aspects of the case as those technical aspects evolve. And so I think A, being credible, and B, thinking about damages from the beginning as being as important as infringement and validity will improve your damages cases in front of that jury dramatically.
Excellent. Bernard, did you have a comment?
Go ahead. Yeah.
I think we probably have time for one more topic, and then we'll take some questions because we've got till about 3:30. But we should probably talk a little bit about SEPs and standard essential patents and where we think that's headed. In the panel before this, there was a discussion about perhaps an uptick in International Trade Commission cases, ITC cases, where injunctions are potentially more readily available. Also, an increase in litigation in Germany. Europe, Germany, and the UK have a fairly developed set of case law regarding standard essential patents, and the back and forth negotiation process that needs to take place in order to preserve defenses. It's probably fair to say that in the US, at least that aspect of the law may be less developed and there are things more in flux. But do the panel have thoughts about where we think the courts are trending when it comes to standard essential patents, and especially how to value them when you may have a standard that is arguably the subject of thousands, maybe tens of thousands of patents, and companies think about, royalties, royalty stacking problems and how many times they can afford to pay royalties when they're approached, by 10 companies who may allege they have patents related to a standard. So maybe we could just go around a little bit. Matt, you could start.
I'm happy to start on that one. There's a couple of interesting issues that come out of that. I mean, obviously several. One is the degree to which you have to have conducted a FRAND negotiation and reach impasse before you may sue. If you have acknowledged FRAND obligations by virtue of your participation in a standard-setting body relating to the patents in suit, then at least the ITC, for example, will typically require you to plead that you have had a FRAND negotiation and reached impasse before you're allowed to file. And if you don't, then you're subject to arguably an expedited proceeding to decide whether you're able to do so. Germany is interesting because Germany, in addition to using the contract basis for such a requirement, has a competition overlay which also requires it even if you are not a participant in the standard setting body at all. And that law in Germany is a little in flux, but you litigate at your peril even if you have no contractual obligation at all, if you have not attempted to negotiate to impasse a FRAND discussion with the defendant. In U.S. District Court, it's interesting. The risk that you run is a parallel case that seeks an injunction against any litigation until you've had a FRAND discussion. And that has happened. It's rare, but it's certainly a risk that you have. It goes into your calculus as to, in the U.S., if you don't have a contractual obligation, you're probably safe from that. But if the contractual obligation is unclear, because different patents often come from different standard setting bodies, and even within a single standard setting body, the extent or existence of the contractual obligation may vary by year. And it may vary by whether you inherited the patents or were the person actually participating in the body. Those rules all vary by standard setting body and vary by year within standard setting body. So the first question is whether you have FRAND obligations before you sue. The second important question then arises: how do you value the FRAND encumbered patents, and what process do you use to do so? And that varies to some degree by what standard setting body you're talking about. If you have a standard setting body where the number of patents is known and small, for example, Judge Robart's decision, it's relatively easy, well, not relatively, it's easier to do an analysis because you know what the denominator is. If you're talking about all patents allegedly essential to LTE, no one has a clue what that denominator is. There are thousands of patents declared. Probably 20 to 25% of those are not really essential. There are all sorts of patents that haven't been declared that probably are essential. And so the idea that you're going to do a coherent, reasonable analysis taking into account the value of these patents versus all of the patents, I think is fantasy. And then you have to look at what other deals are in that space and try to reach analogies based on that. But it's a very, very difficult question to which the law has provided no coherent answer yet.
Thank you. Morgan, would you care to comment, or Ken?
Let's see. One quick thought was that I remember coming to the Hill maybe 5-6 years ago and talking to Senate staffers about standard essential patents. And they were really surprised that there were thousands of patents called standard essential patents. So that's another oddity about SEPs. As far as what's interesting in this area is the tension between national laws and the international obligations that these companies have undertaken when they declare their patents as essential to a certain international standard. So we have this very interesting developments where each national court or national regulatory agencies say, we are going to tell you what that SEP rate is going to be. And then what? When you have a couple different courts or competition authorities saying that SEP rate for this standard should be this, and that differs from other national agencies, then how do you reconcile those two? This is actually may happen because European Union they are going to release guidelines as to what SEP rate is for certain telecom standard by the end of this year. Japanese Patent Office is saying that they're going to do something similar. And then we have Judge Burgess out of UK, who in Unwired Planet case that there should be only one SCP rate worldwide, and he gets to decide it. So I don't know who's right.
Good luck with that.
So I have some quick thoughts just going forward. I think where we are now is unsatisfying for most people, most companies. So standard-setting organizations, rather than simply saying, okay, you agree that you're going to have reasonable non-discriminatory licensing, may in the future say exactly what that means with a number attached to it, because a lot of the disputes have to do with what's reasonable. Is it $50 or is it 2 cents? Second, this is an area where government naturally belongs potentially as having a meaningful role in the Federal Trade Commission in the United States, has been keenly interested in this area for decades. And I think their interest will continue, and they will help shape the law. Third, I think people are going to think about brand new models. Just think about the fact that you could open a bar with 3 bar stools, and you can play in your bar the most popular music of today. And no one's going to come knocking on your door suing you because you pay a few pennies to ASCAP or BMI, and it works. It's a system that works, and the royalties get distributed to the artist or whoever owns the song. So it might be standard-setting organizations do things differently, government entities do things differently, or there's a whole new model that's applied to this area of patent law.
I did hear one creative solution proposed in an academic conference. Someone who obviously has never done litigation proposed the following, that in the first case involving any standard sentence or patents, the district judge would declare a proceeding that would invite all participants in that standard, get every single party, bring them in as parties to that proceeding, and determine on a patent-by-patent basis what the value of all the patents were. And I said, well, good luck with that.
A lot of exciting things to come in the area of patent remedies. Are there any questions for the panel? We have a few minutes left. Any questions? Sure.
This question is for Mr. Chu. Imagine that you had that Wharf case, not before the judge you had, but a judge would only give you 10 hours per side, and that you essentially got 3 hours to put on your damages case. How would you have done it?
We had very, very strict time limits, actually. It's less than 2 weeks. I'm thinking it was probably 7 or 8 days worth of testimony.
You had 7 witnesses. About how much time did it take to get those 7 witnesses?
All the lawyers handling witnesses from our firm were asked to speak very rapidly. It depended. Some were quite lengthy. Some were relatively short. And as I think people who do trial work know, you can put an expert witness on the stand and say, introduce yourself and what's your opinion, and then leave it for cross-examination to lay out all the details. So that worked out well. I think it worked out well for both sides to have very strict time limits. In fact, I don't know of a single district court in the United States today for a patent case where there are not time limits, and they've gotten stricter and stricter and stricter. And I don't think there's been any diminution in the quality of the presentation for plaintiffs and defendants, or any decrease in the quality of the decisions.
So I think I have at least one case where I think that's not the case. I mean, so one of the things that I've been concerned about is the very strict time limits, and what it seems like, so I sort of go through transcripts occasionally and look to see what's happened, and particularly in the damages phase, and it seems like to me, and the litigators can talk about whether this is happening, you guys get time limits, and it seems like most of the time, I suspect that you allot, sort of in your economics, more time to damages and remedies than you initially, and that what inevitably happens is it gets jammed in some way that is either uncomfortable to ridiculous, And so, and maybe Ken can shed more light, because for a while, I was an ardent follower of the Apple Samsung first trial through the damages phase, and that one I sort of left off after 1,000 pleadings in two. But in that first trial, I actually, one of my funny things I show my students is guess how long the direct testimony, the conjoint analysis was. And I don't know if were you there? It was about 2 minutes and 40 seconds. So that was the entire direct testimony. It was more or less like, to the expert, hey, you're a pretty smart guy, huh? You got a lot of credentials. Yeah, I've done a lot. I published 100, publications. What about this conjoint analysis? Oh, yeah, it's a really, accepted methodology. How much you come up with? $1 billion? All right, sit down. I don't think that's the way we want to conduct damages trials. I mean, that might have been the right answer, but we certainly didn't verify that. So I think there are some concerns there. And maybe that's an outlier.
Yes, go ahead.
There was some commentary this morning about the law of enhanced damages after the Halo case. Any comments from this panel?
My personal view is that there has not been a substantial increase in the amount of enhanced damages or the periodicity or frequency of it. I think perhaps the most significant effect is that evidence is now often in front of the jury deciding infringement. But I don't think you're seeing a large amount of increased actual enhanced damages, because ultimately that's a decision for the court, and the court is making that decision anyway. So I haven't seen a lot of it. There's some statistical uptick for sure, but it's not mind-changing.
I would say that the enhanced damages today is not a troublesome area of the law, because district judges have the discretion not to enhance at all after a finding of willfulness. And my experience has been, when a plaintiff has secured a very healthy damage verdict without enhancement, then there will either be no enhancement or very modest enhancement after a finding of willfulness. On the other hand, if the compensatory damage award is very, very small, then there's more likely to be a significant enhancement up to a trebling. I'm saying that district judges are pretty good at balancing the various interests on whether they do or don't enhance after a finding of willfulness.
One more question? Okay, thank you very much.
You know what I'm talking about, right?
No comment.
Okay.
Thank you all for yet another deep, substantive panel. We're going to take a 10 to 15-minute break and then reconvene for our final panel of the day, Case Law Year in Review.
Thanks so much.